So if a company wants to contest the ATO or AusIndustry for one of their R&D claims, where do they take it to? There's two places to take it.
Well, there is. There's two forums. You can go to the Administrative Appeals Tribunal or the Federal Court of Australia at first instance, and there's important distinctions between the two that you should take into account. We usually recommend the Administrative Appeals Tribunal because, unlike the court, the Administrative Appeals Tribunal actually will stand in the shoes of the decision maker and will be able to re-exercise on all the evidence that you present to them. It can be new evidence that wasn't before the original decision maker, the decision, and come to an outcome that is based on that evidence. The great thing about the AET as well is it's not a cost jurisdiction, so if you will never have costs of the other side awarded against you if you lose, and the application fee is usually around about $990, which you'll get back if you win. So the AET is a good place to start, but the Federal Court is a bit different. If you go straight to the Federal Court, you're usually going on a question of law. It's the question of whether or not the regulator had erred at law when coming to its decision. It's a much narrower review, but at the same time, it is much more expensive. The filing fee for the Federal Court is usually in the range of $5,000, and you usually have to engage very senior barristers very early on to conduct a full judicial review of these decisions. So the two options are very important. You might end up in the Federal Court anyway if the AET decision is appealed, but ultimately we believe that on a factual basis in these cases that are so dependent on evidence, it's best to start in the AET.